Welcome to the Personal Injury Law Show. This show talks about everything current in the law of personal injuries and of importance to you, the viewer. My name's Tony Carbone. I'm a lawyer of over 25 years' experience. With me tonight I've got Nunzio Tartaglia, a partner in the law firm in insurance law. Good evening, Nunz.
Good evening, Tony. Good evening, viewers.
And Jess Rosla works in insurance law in a law firm. Good evening, Jess.
Evening, Tony. Evening, viewers.
Viewers, tonight the episode is relevant to you because we're talking about reforms to the Wrongs Act. That is, reforms to that piece of legislation that deals with people that get injured in public places, in occupiers' liability circumstances and the like.
Before we kick off though, Tony, what's in the news?
There's been a lot of stories. This one that is really interesting is cage fighting. Jess, what do you know about cage fighting?
Not a whole lot, to be honest, Tony. But what I can tell you about the reforms is that there's a ban on cage fighting has been lifted recently, and I think it's set to launch in November this year.
And Nunz, your take on this, do you think it's a good thing? Or
well, it seems like everything the Liberal Party wanted to do, the Labor Party is opposed, so it's vice versa at the moment. But look, it's I think there was issues around the safety of the fencing and how that will obviously have, unfortunately dramatic effects. But they've lifted the ban. I think that the safety is adequate enough, and it's going ahead in November. So it's a very popular event though, Tony. It's worldwide. It's massive.
Well, it's massive in the States, isn't it? Look, I guess the big issue here is the moral thing about does it encourage violence and behaviour like that in society?
Yeah, look, I'd say, they allow, kickboxing, they allow, boxing. So, I can't personally see how this is much different. And look, it's the,
Well,
Yeah.
we'll probably come back to this in due course after we've had our first cage event. All right, let's talk about this shame of hell riders. There's a group of riders every weekend that go hell for leather, helter-skelter along Beach Road, and the winner takes all. Tell us a bit more about this story.
Tony, I've witnessed it. I said I live nearby, and I've seen these riders on a Saturday morning, going nuts. It's like a race, really. And,
it is a race.
What's happening is it's causing dramatic effects on the road because they're knocking people over. They're not waiting to see if they're okay. And some people have sustained some serious injuries, including spinal and facial injuries.
Yeah.
Well, Jess, what these people don't realise is the people that they're injuring, they will be sued, won't they?
Yeah, most certainly. I mean, the people
that have knocked them off their bikes.
We'll bring causes of action against them. I think one of the difficulties, though, and the purpose of this article is that no one's speaking up to say who caused the injury. And given the big number of people there...
There's about 100, I think.
Yeah, there's a lot of witnesses, and no one's kind of coming to the table and saying, yep, I saw it, or I stopped to help, which is problematic for the injured party here.
Well, there's two instances. One fellow, 60-year-old, has got 6 broken ribs, punctured lungs, which is really significant. There's also another lady who's got a fractured skull, and bruised lungs, etc. Look, apart from the fact that they're going to be liable civilly, they can and will be prosecuted from a criminal perspective, won't they?
Yeah, they could. And also, if they're fleeing the scene of the accident too, if they've knocked them over.
Yeah, there's an obligation to stop.
Yeah, that's right.
And the issue I have is that if these riders don't or haven't taken out insurance through Bicycle Victoria or anything to that effect, I'd hate for someone who's injured not to have be able to actually receive compensation.
Exactly.
And that's a concern.
And my view now, based on that case in particular, and also the fact that now they're trying to introduce electric bikes, we need registration.
No doubt, and I said I think it gives everyone some safety on the roads and some protection. So.
And also,
definitely.
Jess, wouldn't you think that the Bike Riders Association should encourage the bike riders to take out insurance to cover other people?
Yeah, most certainly. I think that will encourage accountability as well for their actions.
Nunz, have you got a punching bag?
No, I don't, but sometimes I feel like I need one.
Okay. Well, you'll be surprised to find that this particular fellow bought a punching bag years ago, For some reason, I don't know why, but he decided to open up the bag, and what did he find in there?
Yeah, so Tony, this poor gentleman purchased a punching bag for his sons and opened it up to replace a latch, and unfortunately found in there a whole array of rubbish, including needles, medical waste.
Broken glass.
But yeah, broken glass. It was just, I mean, thankfully it didn't cause injury prior to or whilst the kids were playing with it. But it's really incredible how this has occurred.
This fellow did get pricked by a needle, didn't he?
Yeah, I believe so, Tony. Yeah.
But geez, I'll tell you what, you buy a punching bag, and I guess what would you expect in a punching bag?
Well, you'd imagine some kind of firm material to keep it, I guess, in form, but certainly not medical waste, I would have thought.
Well, since Spalding obviously recalled the product,
All their products.
and they're gonna, it'd be remarkable to see if they're all similar or and how they got in there, because they're attesting to the fact that their safety procedures are first to none. And
It sounds like a case of sabotage to me.
I don't see how.
All right, there's a story of this teacher that wants compo after falling from 2 steps off a ladder. Tell us a bit more about this, Nunzio.
Yeah, so she was taking off I think artworks from a wall, and she fell 2 steps off a step ladder. So look, it sounds a little innocuous, Tony, but she issued proceedings in the County Court of Victoria and unfortunately lost at the County Court, and has since appealed, and we're waiting on the verdict from the Court of Appeal.
Well, Jess, she was carrying items in her hands. She was really loaded.
Yeah,
so,
that's
I mean,
right.
it's hard to balance.
Yeah,
even
and
if it's only 2 steps.
Yeah, correct. And I think, touching on what you've both said, sometimes these cases on the face of it seem like there's not really much meat in it, so to speak, but realistically you've got an employee who suffered quite significant knee injuries here, and there are strict obligations for an employer to provide a reasonable workplace and have training for these types of...
And there's got to be a risk assessment when you're carrying out these tasks.
Yeah.
So I'm not even sure if that occurred. So...
Yeah, and I think the article quotes basically the barrister saying that, that there was no system of work, as Jess mentioned, and that she can't be forced to come up with her own system. It's not how it works. So interesting to see how she goes, but
and
difficult one.
Do you know that the majority of deaths and serious injuries in households are caused by ladders? Can you believe that?
Not surprised, because you're at high, you're at heights and with no guarding at times.
Well, I don't even know if you need heights, because here it's only 2 rungs and you still lose your balance.
Yeah,
because it depends on what you got in your hands.
Yeah.
All right, what about this vile granddad that got $830,000 awarded against him, Jess?
The facts of this are quite upsetting, Tony. This 65-year-old grandfather who's currently incarcerated apparently set up a church or a cult, so to speak, a couple of years ago, and had, I think at best, about 60 people under his care, and unfortunately used that authority to molest and assault his children and grandchildren in this case.
Look, it's disgusting, Tony, and look, I just hope that the award of damages he can actually pay, so they get some compensation.
Yeah,
for
he
what
might
they've
have
gone through.
property, you hope.
Yeah, you hope.
Because he was an engineer, so...
You hope, and that's all you can do at this stage, unfortunately. So.
Viewers, we've got to go to a sponsors break. Stay tuned. After the break, we'll bring up to date with some changes to the Wrongs Act. Welcome back to the show. Today we're talking about an episode that deals with the Wrongs Act. What it talks about is public liability, occupiers' liability, and people getting injured in public places, including supermarkets, footpaths, and the like. Now, in 2003, the most significant reforms that have ever been made in this state occurred when the Wrongs Act was amended to introduce thresholds into the system, which you have to satisfy before you can launch a claim for pain and suffering, Jess and Nunzio.
Yes.
The most significant threshold was you needed more than 5% for physical injuries and you needed greater than 10% for psych injuries. Now, Nunzio, the YIP review in 2002 and 3 recommended changes because the public liability system was becoming too expensive. Is that true or false?
The data seemed to suggest that the cost of public liability insurance was becoming too high, and that's why they wanted to put in some thresholds. But then I think when you really look behind the data, they weren't increasing. So you've got it makes you wonder how those changes actually came to effect and how they got through, because the data wasn't supporting their position.
And Jess, since the changes, which has led to a massive reduction in claims, the insurance hasn't dropped.
No, well, as Nunzio was saying, Tony, it doesn't look like it has, based on when you look at the real figures in front of you.
Tony, you've obviously practiced in public liability for 30-odd years, as you've said at every show now. Now, what did
something to strive for.
You're best to commentate on the changes from 2003 pre and post. What was your take on it when they first got implemented? How did it change things?
I thought it was pretty unfair in the sense that you've got to have a significant injury. That's what the law talks about. Now, in a lot of instances, you do have significant injuries that don't get compensated because the system of assessing the more than 5 or 10% is very arbitrary, as we all know. And you've also seen many cases involving backs, for example. Yeah. One gets more than 5%, and the next one, similar sort of circumstances, doesn't get it. Correct?
That's right. Exactly right.
And I guess one of the biggest problems with the system is that you can't have 5 or 6%. It usually jumps. I've got 5, 10, 15.
Yeah.
It's very rare that you get the odd numbers. Is that correct?
Yeah, exactly right. And it's unfair in the sense that sometimes in some accidents you can suffer multiple injuries, and you're a better chance of getting over that threshold, whereas you might just have one injury, but it's so severe, but you still don't get over the 5%. Exactly. I just don't see how that's fair.
Well, Jess, I would have thought the most important thing for them to do is change it. Instead of saying more than 5, it should be 5.
Yeah.
Or more than 10, it should be 10.
Yeah.
Yeah, well, that would be a significant change.
Correct. And you hit the nail on the head there, Tony, because I think a lot of the submissions to the inquiry that was made into the Wrongs Act touched on those two specific things, and we'll go into that in some more detail as we move forward in the show.
Okay, now let's talk about some of the recommended changes.
Yep.
One, they were saying widen the access to damages for non-economic loss, that is pain and suffering, by reducing slightly the existing threshold. Well, basically, that's what I just said.
So the proposed changes, which, look, I'll go back a bit. The government had looked at these recommendations and made. This is the old government, which is a Liberal government, had looked at these changes and made their recommendations of what they'll support and not support. Now, with the obviously changing government, we're in a bit of a standstill as to what's going to happen with all these. So hopefully, the Labor supports a lot of the recommendations. But the big one is the non-economic loss, the 5%. So what they're saying is that instead of having greater than 5% for spinal injuries, it should be 5% or more, which would, I think, help a lot of plaintiffs.
I think so.
Yeah, definitely.
And then it says provide additional compensation for pain and suffering to severely injured persons by slightly increasing the cap on damages. What is the cap at the moment, Jess?
It's about $500,000, so it's indexed every...
So it's 371 prescribed in the Act, but then it's indexed, which gets to about 500,000, as Jess said.
Yeah.
And the proposed change is to get to the same as work cover, which is around 571.
570, yeah.
Which is not much, really, when you think about it.
Well, it's not much, but at least it's uniform. We're at the top end in terms of the public liability med-neg areas. If anything, TAC is going to be a little bit low now because they're at 500.
Oh, okay.
Yeah, same as Wrongs Act. Yeah. Going back to reducing the threshold, the other change that's been recommended is the threshold for psychiatric injuries, which there's now support for that to be brought down to 10% as opposed to greater than.
Yep.
So that will assist.
And Jess, does that work the same way as Tony was saying before, where you have to get increments, so 10 to 20?
Yeah, that's
20
exactly right,
yeah.
and which has often knocked a lot of injured plaintiffs out of the system, unfortunately, because they seem to sit just on the borderline and not greater than, which is surprising that it wasn't looked at when the changes came in, to be honest with you.
But look, for the average viewer, why would psych be so much higher than physical? You go 10% as opposed to 5%.
Yeah, look, they're different guides, so they're obviously they're rated on different scales, which is difficult. But I suppose for the viewer, to give a real-life example, Jess and I had a recent matter where a client had a slip and fall at a supermarket and sustained a back fracture and nasty injury, a lot of rehabilitation, still ongoing problems. And was sent to the medical panel, which assesses you whether you're over the 5% threshold, and unfortunately she didn't get over. And you don't know, you're not told as to what percentage she was given. You just get told...
That's either more or less.
More or less,
That's
and
right.
you have no claim. And look, this particular client is shattered because she's got these injuries for life, Tony. And that's why I'm hoping the Labor government really adopts these changes.
Well, Jess, just on that issue of the back, assuming this particular individual's taking a lot of medication and suffering the after effects of medication, like significant reflux or abdominal symptoms and things like that, would you add that in there as an injury?
Yeah, look, you certainly could, Tony, because that's something that can be assessed as well and which can quantify into an impairment percentage.
So that could assist you in getting more than 5%?
It could.
But Nunzio, a lot of it's going to depend on whether you've got pre-existing symptoms too, isn't that correct?
Yeah, so all that's factored into that. Look at your pre and post accident history. So, it's important that, you go see a solicitor because they'll access all your records and they'll put submission as to why you should get over that threshold. And, and that's why it's also important you see doctors and tell them about every injury you have. They said if you've got stomach problems because of medication, you tell the doctors.
One of the things I find really disconcerting is that under the transport accident and also work accident laws, we've got what they call a narrative where you can assess your case as against all similar cases to yours to get you over the threshold. But under public liability, they've never introduced a narrative, and they don't want to introduce a narrative.
No, so there was talk of introducing a narrative test, but it's been sort of hit on the head, not going to happen, which, look, I can understand why, because, I think that would blow out the costs of litigation.
Viewers, stay tuned. After the break, we'll explain to you what this narrative means and any other proposed changes. Welcome back to the show. Just before the break, we're going through this very convoluted and complicated system that we know as our Wrongs Act. Now, I mentioned a narrative. Under work cover and TAC, if you don't satisfy the test to get a serious injury so you can sue, we've got what they call a narrative test, which means that,
the story of your injuries.
It's the story of your injuries, And if you can prove that it's caused significant changes to your lifestyle, you can proceed with a claim. But you don't have that under the Wrongs Act. And it's highlighted by this case of a 14-year-old boy who had a degloving injury.
Tony, exactly right. That's unfortunately, I think, the fault of the system, because you've got this 14-year-old boy who's got, degloving injuries is very significant, and unfortunately, he didn't get over the 5% impairment, so he can't sue for his pain and suffering. And despite how strong his case of negligence is against the relevant occupier, he cannot sue for his pain and suffering at such a young age. And other example is that we had a client had a left knee fracture with, had surgery with plate and 9 screws, didn't get over 5%. And that's just not right.
And he needs a knee replacement.
And that's where they're saying they've got to balance the rights of, obviously, the insurance premiums and making sure it doesn't blow out, but also protecting people that are injured. And that's the balance that I think they haven't got yet.
And the funny thing about it is those two examples you've given, Jess, if they're under the transport accident legislation or work cover law, they'd both be serious injuries.
Yeah, absolutely, Tony.
And serious injuries are higher test than significant injury under the public Wrongs Act.
Oh, look, a left knee replacement under work cover would be a Monty, wouldn't it, Tony?
Oh, of course, of course. Jess, the cap on non-economic loss, they want to increase that. Can you tell us a bit more about this?
So what they want to do is bring in the cap on non-economic loss, which is pain and suffering damages, otherwise known as, to bring it in line with the work cover legislation. So currently the cap is just under 500,000 or so, and they want to bring it in line with the work cover legislation, which is 571,000.
Now, Nunz, let's move on to damages for loss of capacity to care for others. Sullivan and Gordon damages.
Yep.
What's this all about?
So there was a case back in '99 where it was determined that you can claim for damages for loss of capacity to perform services for other people, and unfortunately that was then overturned by a High Court case, and that's now the basis of these proposed changes. They want to codify that you can claim the equivalent of what's called Sullivan damages, which I think is a great thing, and it appears that it has got the support of the ex-government, but hopefully it's the current government as well.
So, in effect, what they're trying to do is introduce gratuitous personal or domestic services for another to recover damages calculated by reference to a commercial value.
Yeah.
So what, say $30 an hour, for example?
Yeah, thereabouts. And I think Victoria is quite behind in comparison to the rest of the nation in that sense, because after the High Court had made that decision, South Australia, ACT, New South Wales and Queensland, I believe, implemented changes to their own equivalent of the Wrongs Act to allow plaintiffs to make a claim for lost capacity to provide care for others. So a good example is someone who perhaps is a carer for an injured relative or with a mental incapacity, for example. They've then been injured and has lost capacity to provide that care, and then they're claiming the allowance. In Victoria, there's no provision to claim that.
Well, in effect, it means you've got to put them in a nursing home if you can't look after them.
Exactly right. And that's what I think in the case of Eddie, where they overturned that Sullivan decision, they said, it should just go to pain and suffering, which I don't think is right, because it's not really your pain and suffering, because you're actually doing a service. I think it should be another head of damage, which it now could be.
Look, there's a number of changes they're proposing. What about this one in relation to aviation cases, Nunz? What are they proposed to do in that?
So aviation cases, Tony, and look, we're going to have an episode of this one shortly. Look, generally it's a strict liability regime, so whereas if you get injured on a plane, generally you do receive compensation for the injuries you sustain.
Provided it's an accident.
That's right.
And not your fault.
Yeah.
Exactly right. So what they want to do is, I think they want to sort of scale this one back a little bit, and what they're saying is for those who suffer psychological injuries in these circumstances, unless you've suffered personal or property damage as a result, you can't claim damages.
Why would they want to do that? I mean, it's just...
Yeah, I mean, it's difficult because you'd imagine a lot of people could suffer pure psychiatric harm being involved in an accident, even if they're physical injuries or they don't have any physical injuries.
Yep.
And at the current state of play, there's no provision to recognise those injuries.
But under the strict liability regime, doesn't that mean that if you're injured on a plane and it's not your fault, you get paid every time?
Provided it's relatable to a personal or property damage.
And there's no 5% threshold or 10%? No. Which is good.
Yeah, and look, that's why I think those cases do generally resolve quite quickly and expediently, and I think it's something that should be trying to be adopted a little bit. So,
Jess, is it fair to say, or am I being harsh to say that the system as it currently stands is almost like a lottery?
Look, it certainly does seem that that's the way it plays out at times, Tony.
Yeah, look, I'm finding that we're getting some clients who have suffered some really dramatic injuries that are just not getting access to compensation, and that's not what the system should be about. It should be fair, rewarding those who suffered injury by reason of someone else's fault.
And look, I can compare the public liability system to work on TAC. Yeah. I find that some of the examples that your department misses out on and what we do in the other jurisdictions, it's just extraordinary.
Yeah.
I mean, a lot of those cases that you guys miss out on, where the test is a lot lower, we would otherwise win in work cover and TAC.
Because the narrative test, like you're saying under work cover and TAC, is your story. It's how has my injury affected my life? And sometimes, you might think it's innocuous, it affects your life more than anyone. And, and unfortunately, under public liability, there's a threshold, there's the test, unless you're over it, forget about it. And there's just no room for leeway, which is, it's unfair.
And also, when you do a narrative, you can say that what medication you're on, what treatment you're getting, what proposed treatment you're going to have in the future. Isn't that correct, Jess?
Yeah, that's right. And I think another, just to mention by the wayside, is that under TAC and work cover, you can get access to medical treatment, whereas under the public liability or professional negligence areas, clients...
You have to fund it yourself.
Yeah, clients don't have that benefit.
Yeah,
so,
that's an important thing that you've raised there, Jess.
Yeah.
Look, we've come to the end of the show. Jess, thanks for coming on board. Nunz,
Thanks for having me.
Thanks, Tony. Thank you.
Coming on board. Viewers, thanks for watching. Go to our website, Facebook, Twitter, past episodes. Stay tuned for future episodes, and always remember to stay safe.